So many people lose custody to a narcissist, and I don't want that to happen to you. What I'm going to be talking about today is how to recuse a judge in a family law custody case, family court case, um, whatever you want to call it. Uh, but I mean, this is a general rule of thumb for any civil cases, really. And I'm talking about a very specific scenario where the judge is not uh, doesn't have some conflict of interest like financial, personal gain, political gain, those sort of things. I'm talking about when the judge's impartiality becomes a matter of contention. And um, first and foremost, let me just say that this video also is not legal advice. I'm not suggesting anyone should do this. I'm not, you know, giving you instructions on how to do it. Basically, what I'm just saying is here's how I did it. And, you make your own decisions in your own case. I'm not your lawyer. I'm not a lawyer. Um, but I have done this on motion and I was successful. And people are interested in how I did that. So I want to talk about it and share my knowledge and share how I did it. Um, so the very specific scenario that I'm referencing is when a judge's impartiality becomes in question, and this is not going to be um, a like one or two instance thing that happens, and you're like, oh, recusal. No, like if it is that situation, it's probably because the judge said something about you personally, and those comments undermined like you as personally as a protected class, right? Like if the judge was saying racist things to you, if the judge said, "I don't like men" or "I don't like women," um, that would be enough for a one instance thing, but it's very unlikely that that is going to happen to you. What usually happens in these situations is you've been in front of the same judge for quite a while, usually at least a year, because you're going to have to at least probably go before trial in front of this judge. You're probably going to have other rulings regarding discovery, um, motions to suppress, any of those sort of things, motions to compel. Like this is a long game strategy. It took me 14 months to get to this point to be able to say, okay, I can move forward with the recusal now. Um, so this is not a easy strategy. It's something that if you think it's happening, keep it in the back of your mind. Keep a list of the facts. Um, but just know that this is not going to be a 1 month, 2 month, or even 6 month strategy. If you feel like the judge in your case is biased, it's probably going to take at least a year um, of the same judge being assigned. And what happens is, at least what was happening to me, was that all my motions were getting denied. I knew I was putting solid law in them, solid citations from appellate cases and appellate opinions. I was checking on, if there was a rule regarding judicial estoppel or something like that. I would go look up the appellate court, what was the three-part test, and then I would apply the facts of my case to those appellate elements to, make to get to the end result of the legal doctrine that I was trying to argue. So you, it's not easy because you have to make sure that the law that you're citing, your citations, the rules, the doctrine, all of those sort of things that make up the entirety of the law, because it's not just a statute. It's the statutes plus what the legislative intent was, plus, okay, in practical terms, how does that actually apply to facts in certain family cases? Um, how does it apply in this instant in a family case? Oh, if this happened earlier. How does the rule apply here? Like, it's a lot, and you basically have to know that what you're doing, and it's hard if you're not a lawyer, but you basically got to know that what you're doing is better than what the judge is denying, which is very hard because there are a lot of judges out there that think that pro se people are trash, and the reason for that is there's a lot of different reasons, but the main thing is, hey, I'm a judge. I'm a public official. I'm so good at the law that I get to make rulings and control people's lives every day because that's how good I am at the law. I went to law school. You didn't. I've been running in this circle usually for 20, 30 plus years. I'm a member of the bar. I'm a member of, um, like a lawyer's in, like, uh, you know, I went to law school. I did this, and how could you know? You're nobody. You're not in the circle. You're not, a practitioner of law, and so, you know, it it goes to their head. They're human beings. So let me just start with that. They are human beings, right? And it's natural to feel that way. I can understand it. But at the same time, when you have people coming before you and you're letting your ego get in the way of people's due process and it's affecting how children's lives are affected, the outcome of a child's life, um, that's a cause for concern. And when a judge is letting their ego run the case and their bias run the case versus actually following the law, following civil procedure rules, making sure that the court is fair, balanced, neutral, um, it's a government overreach, in my opinion. And like, I'm just the type of person that feels like government should be in check. This is how I am. I don't think that the government should run every aspect of people's lives, but that's another topic for another conversation. Um, but the point of what I'm trying to say is, uh, I probably had about 10, maybe more instances that I could point to that were going to be undeniable, uh, undisputed facts that happened, that when I applied them to the law, to the case law, your tried and true appellate opinions, and when I said, okay, now how does this contrast with the judge's ethical duties? And when they when I looked at my facts and they were not congruent with those ethical duties, I said, okay, I think I have enough to move forward here. Um, but to give you a few examples of the kind of stuff that you would need to cite, um, or that I cited, were things like during my cross examination at our last trial, my ex brought an issue into the case, and during my cross, I was trying to erode her credibility. And that's my right under due process. And I knew it wasn't credible. I started working on it, to undermine it. And at some point during my cross, the judge, I thought he was going to come up out of his chair. He certainly raised, his chest and yelled at me basically and said, I've had enough. She's acting out of the goodness of her heart. And like, a judge cannot advocate for someone's intentions because it becomes almost like a testimonial um, advocacy on the judge's part of the opposing party. And the judge is not supposed to make those determinations until after the trial, once all the evidence comes in. So that was a huge red flag to me, and I knew it back then, but I didn't know how to argue it back then, and I didn't realize exactly what it was back then. But I always knew in the back of my mind that that seemed wrong. So doing that is extremely prejudicial and in violation of someone's due process. So that was a huge one for me. Um, and then during our modification now, I filed a motion to compel. And the judge is like, you got to show me all these good faith efforts, blah, 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 blah. And sure, the rule does say that. That's not what I'm disputing. What I was disputing was back in our previous modification, Her lawyer asked for a motion to compel, and they didn't have to show any good faith efforts. The judge just granted it. So you have a judge that's saying, okay, well, if a lawyer's doing it, I'm giving them all the grace in the world. They get all the latitude to break the rules. And for you, Mr. Brower, we're going to make you stick exactly to the letter of the law. And if you don't do it, then guess what? It's on you and not me. Well, that's not exactly true, right? Judges are supposed to give people equal protection under the law. And so that's what I cited for that example. Um, and again, equal protection under the law is also, goes in line with, protecting someone's due process. And it's like, if I'm going about discovery the exact same way that the other person is, but you're denying it to me and giving them latitude, then how am I supposed to know which rules you're going to follow on what given day, and why you're following the rule or making one person follow the rules and not the other person, right? So then it becomes a matter of, I don't know what to do, because every day is a different way that you're going to follow the rules. Um, so that was another big one. Um, and then at the end of our last trial, the judge said, uh, the court prefers to work with attorneys when writing the order. And on face value, that might not be like a huge deal. But when you have these patterns of other things, and he's not making the attorney go through good faith efforts to follow the rules and things like that to compel discovery, but then he says, well, I prefer to work with attorneys on writing orders, then it's like, hey, the judge is telling you flat out, if you're not an attorney, I'm not going to work with you. And, a reasonable person could also presume that walking into this judge's courtroom, you're prejudiced and prejudged because you're not an attorney. He wants to work with attorneys to write the orders, so he's probably going to do whatever he can in his power to find the party with the attorney as the prevailing party, because he said flat out, I prefer to work with attorneys. So of course he's going to lean that way. But that has nothing to do with the merits of the case. That's what I would say is extrajudicial. It's not pertinent to the facts, right? It doesn't matter in evidence, any of those sort of things. So that was another big one. So that was my third or fourth big one. And then what I had that was sort of like the dagger, the undeniable dagger, right? I had filed a modification. My ex was served properly, all that sort of stuff. And sorry, I got some in my eye. I filed a modification for custody. My ex was served, and her defense that she replied to my petition to modify with was that there had not been a material change in circumstances. Um, I knew there had been, but whatever, if that's the defense she wanted to go with, great. So she goes with this defense. We get our scheduling order for propounding discovery and that sort of thing. So I propounded interrogatories to her and admissions. Um, and both of those were strategically done, and they were done with the state of mind that there had not been a counterclaim filed by her. She missed her deadline to file the counterclaim. Well, when she realized how fatal of an error this was in um, in family law in general, um, she filed a counter complaint that was 67 days late after her deadline to file it. And what that did for me was effectively she waived the right, and now she has to get permission from the court to file that counterclaim, and she did not get permission either. But in her admissions, the very things that she denied happening were also a part of her new counterclaim. So her counterclaim contradicted admissions that are basically set in stone. And unless you ask the court to give you some sort of relief to withdraw or change those admissions, those are locked in for trial. And Um, Also, part of the pertinent thing here is that the counterclaim was filed after the time to propound discovery had closed. So I couldn't get discovery on these new claims. Like, she held on to it in secret until I couldn't do anything about it in discovery. And knowing that she didn't have a counterclaim, knowing that her defense was there was no modification, I clearly tailored all of my discovery based on her not having a counterclaim. So when that happened, I strategically and by law and by right, because the rule 2-331 in Maryland says you can motion the court to strike by right when a late counterclaim is filed. And there's a ton of reasons for that. I won't get into all of them, but essentially, what you're saying to the court is, hey, she missed the deadline. They were supposed to have done this 30 days after being served. And then, you know, discovery is closed now. There's prejudice here. There's a clear prejudice here. She's trying to get out of the admission she already had made. She's contradicting them with this new filing, all that sort of stuff, right? And in the Maryland Rule 2-331, it says that unless the opposing party, right? So I was the party who was moving to have it struck. The opposing party who had to file an opposition can show that the late filing does not cause prejudice to me, um, shall be stricken from the record. And the shall part is huge for me, and it was huge back then, and it's huge now because I'm still working on it. But the shall part of a rule is a mandatory command of the court. They don't have discretion there, um, because it doesn't say may; it says shall. And when she decided to not file an opposition to my motion to strike, the court had no choice but to strike the um, the counter complaint. And also, the rule says very specifically that the judge, in order to allow the counterclaim to go forward, they have to make a specific finding that there is no prejudice. Well, the judge who I motioned to recuse, guess what? Never made that finding on the record, and he just allowed the counterclaim to go forward. So that was a huge red flag for me. And once I started figuring out the case law and the fact that, okay, how is a shall treated versus a may? And the case law is very clear. Judges do not have discretion where a rule says shall, and where they're required to make findings and they don't. That is an appealable instance, and I finally had it. I had it, and I caught it. So I figured out the case law, all those things, what shall means, and then I filed my motion to recuse and cited all those things I just talked about, how they affect this, how they affect that, um, and my civil rights and all those sort of things. And I mean, I stacked. It was a 7-page motion, which is quite lengthy for family law, but I mean, I had no choice but to stack that thing a mile high, so it was going to be undeniable. Um, and you know, when you are in a situation where you see like very clearly that the court is disobeying its own rules, where they're going out of the way to give discretion where the rules specifically say they have none, like now you're getting into that. Okay, I think the judge might be biased here, and they probably are. Um, and that's what I did. That's what I said. Um, and it worked. The judge voluntarily has requested to be recused from the case, and I am proud of myself. It was very hard to do. It was a grueling 14 months to get to that point, but um, it was pretty awesome to finally get served with that after this judge has denied everything pretty much, and then he had no choice but to grant my motion to recuse. So I'm still quite in shock that it happened, um, because this is hard for lawyers to do. It's hard for experienced, expensive attorneys to do, because there's so many things in judicial ethics that say that, you know, judges are given the benefit of the doubt when it comes to their impartiality, and the bar for eroding that is very high. Um, it's not an easy task. It's not for the faint of heart, because everything leading up to it probably means that you are suffering and you're going to suffer, while you're in the middle of it. But it is possible. You know, I see a lot of people online that talk about suing judges and this, that, the other. And even though I think what this judge did to me was wrong on a legal level and a human level, um, and morally, like, even if I wanted to sue him, I couldn't because of immunity and getting the law wrong, or, you know, being a butthead, is just not a reason that you're able to make a claim against a judge in a lawsuit setting. Um, but again, this is a very, very tough area of law, a very specific area of law, because if the judge is not like somebody's mother, father, first cousin, former attorney, or used to work with the opposing counsel, um, they're not, they don't have stock in the company, they don't uh, have a political affiliation with the other party. Like, proving that a judge is biased is very hard to do. Um, and I see a lot of people online that talk about, oh, my due process this, my due process that. Well, like, I argue that as well, but I did it in a way where it's not just about being heard, right? You also have a right to be heard in a meaningful and fair way, and that's called your substantive due process, right? You can't just being heard isn't enough. You need to be heard in a way that is meaningful and fair. Um, but there's also a lot of stuff in between that, rules of evidence and this, that, the other, and it's a lot that goes into it, but um, I guess I kind of lucked out in a way that I this judge has yelled at me and advocated for the other party's intent, violated mandatory rules that just, when you add it all together, it couldn't be ignored. I went through hell to get there, but it is what it is. I paid attention. I kept a list, and I also kept my motion to recuse very factual, unemotional. In fact, I even put in there, I think I said something like, I have done everything I can to work with the self help lawyers or legal aid. I've done everything to try to avoid this and work with the judge as a personal and professional courtesy. But unfortunately, we've gotten to a place where so many things have been done, so many rules have been ignored, and I don't know what rules to follow anymore, because every day is a different. The judge is using different discretion. He holds my feet to the fire when I don't perfectly cross all my T's and dot my I's exactly as he wants. But then the other person can, file things as sloppily as they want. Use and use that knowing, like, her knowledge was that, hey, it doesn't matter how bad I screw this up, how many rules I break, because this judge is going to go out of his way to make sure that, you know, I I still get to cause this prejudice and harm to me, um, by gaming the system. And, you know, at some point, like, when you see that happening, it's like, oh man, she doesn't have a lawyer anymore. This judge is basically trying to stand up for her and bend the rules in her favor so much that it's almost like he's advocating for her, right? And you can't do that. Um, But yeah, I mean that's what happened. Um, but you also need to cite, like, just like if you were citing a motion. If I was going to cite a motion to strike and I say pursuant to the rule, you know, just as all of these things and the facts that I cited, I said, pursuant to, judicial ethic, whatever, blah blah blah, statute. Um, this is how this fact is not congruent with the ethics of a judge, and here's what it means for, prejudice towards me, my due process, um, equal protection under the law, all that sort of stuff. So I just piled it as high as I could, so that it would be undeniable. And now he's asked to recuse himself. So I'm very proud of myself for doing this. There was a gentleman online. I won't say his name because I don't know if he wants his name in the video, but he said, "That's awesome. You basically have a better chance at seeing a unicorn, because this is a very, very tough thing to do." So I'm very proud of myself for doing it. But anyways, that's what I did. Hope you all find this educational or whatever you want to do with it. That's on you. Again, this is not legal advice. I'm not suggesting anyone should go do this in their case. But if you feel like the judge is biased, they might be. But you really got to stack it high. You really got to pay attention. You got to have solid facts, unemotional motions to recuse. And, oh, God, there was one other thing that I was going to say. Um, and be careful. Be careful, because if you screw this up and you swing and you miss, this is like family court suicide. If you think that this judge is already being biased towards you, um, get ready, because you basically saying that they're violating judicial ethics. Um, if you don't think that's going to come back to bite you in the butt in the long run, it certainly will. Um, so be careful of that. And yeah, just be mindful of what's going on in your case, um, because this sort of stuff does happen. It's unfortunate. Again, I think it's a government overreach when things like this happen, but um, judges are human too, and I get why this is a huge topic of discussion for a lot of parents online, um, because no one is immune from emotions, even the most evil of people. Um, Evil is an emotion too. Evil is an emotional driver for people. So no one is immune from emotions. Judges aren't. Magistrates aren't. Um, you're certainly not. And when you're representing yourself in your own family case, it's very tough because you are emotionally attached, and judges don't like to deal with emotional lawyers. They certainly are going to find it, that it's harder for you to deal with an emotional parent who, is not trained legally. But there are those of us out there who take the law very seriously, and we try to learn and all that sort of stuff. Um, I certainly have. I know way too much about the law. It's frustrating, having conversations with pro se people sometimes, because I've done the research. I've read the appellate cases. I know what goes into a statute. It's not just what's on black and white in the penal code. It's not just what the family law statute says. It's all these different things. What the legislator was thinking of. What time in our history was it? Where was the country at? Where was the entire legal community at? Right? Like that's what the law is. It's not just what you see black and white on paper. Um, and family law is so tough because when it comes to discretionary rulings, there is no black and white on paper. Um, you generally have one big case in your jurisdiction, and they have factors, and that means that your jurisdiction is probably common law. It is in Maryland, and I wish we would change that so at least people could understand what the factors are a little bit better, and take some of the discretion out of it, but at least give people an idea of what's going to happen when they're in a court of equity. Um, and that's another huge thing that people miss. they think that they're in a court of law. In family court, you're not. It's a court of equity. Um, but yeah, that's all I got for now. There's probably going to be a part two to this video. Um, so there's some other stuff I'm waiting on that would be pretty big news, but I cannot talk about it right at this moment. Um, but anyways, yeah, good luck to all you dads out there, all you moms too. I try to be as unbiased as I can when talking about these sort of things in family law. So good luck to everybody.